Did you know that blowing into a breathalyzer without saying one specific sentence first could be the biggest legal mistake of your entire life? Most drivers hand over their breath, their rights, and their freedom without ever realizing they had a choice. That one test can mean a suspended license, thousands in fines, and a criminal record that follows you forever. Hit subscribe right now because what I'm about to show you could save you from a DUI conviction you never should have had. Defense attorneys charge $500 an hour to explain this stuff, and you're getting it free in the next 10 minutes. Here is what you are about to learn. The one sentence you must say before you even touch a breathalyzer. The legal difference between a roadside breathalyzer and the one at the police station, because they are not the same thing, and most people have no idea. The exact words that buy you time and protect your rights in those critical first minutes, and the massive mistake that gets people convicted even when the breathalyzer reading is borderline. These four things together form a wall between you and a DUI charge, and every single one of them is completely legal. This is not about beating the system. This is about knowing your rights before you give them away forever. Let's talk about what actually happens during a DUI stop. You get pulled over, maybe you had 2 drinks, maybe you had 0. It does not matter right now. The officer walks up, shines a light in your face, asks if you have been drinking. And then here's where everything changes. They ask you to take a breathalyzer test, right there on the side of the road. And almost every single driver does the same thing. They either panic and say yes immediately, or they say no and make the officer think they are hiding something. Both of those responses are wrong. Here's the reality. You have a narrow window right there on that roadside to say something that changes the entire outcome of what happens next. Most drivers blow that window in under 5 seconds. They never even knew it existed. Bad way. The officer says, take a breathalyzer, and you say, okay, sure. You blow into the device. The number comes up. Now that number is evidence. It goes in a report. It follows you to court. You have 0 control over what just happened. Good way. Before you touch anything, before you lean forward, before you even look at the device, you say exactly this. Officer, before I agree to anything, I'd like to speak with an attorney. Word for word. Memorize that line. Officer, before I agree to anything, I'd like to speak with an attorney. That sentence is your legal lifeline. Let me show you exactly why it works. The Sixth Amendment gives you the right to counsel, and that means the right to talk to a lawyer before making decisions that could affect your freedom. A breathalyzer result is a major decision. It is evidence, and requesting to speak with an attorney first is 100% legal. Former police officers have confirmed this works. It does not make you look guilty. It makes you look like someone who knows their rights. And officers know they have to take that request seriously. Now here's what that sentence actually does in practical terms. It pauses the moment. It signals to the officer that you are not going to be steamrolled. And it creates a record that you asserted your rights. Defense attorneys use this exact line in court. It has helped reduce and dismiss charges because it shows the defendant did not just blindly comply without understanding the situation. You are not refusing. You are requesting counsel before making an informed decision. Those are 2 completely different things legally. Now let me be clear about something important. If you are in a state with implied consent laws, which most states have, there are consequences for refusing a breathalyzer at the station. But that roadside test, the handheld device the officer pulls out of their pocket during the stop, that is usually a preliminary alcohol screening device. It is different. In many states, the results from that roadside device are not even admissible in court as direct evidence. They are used to establish probable cause. Knowing the difference between that roadside device and the official station breathalyzer could literally change your case. Have you ever been asked to take a breathalyzer test during a traffic stop? Drop a comment below right now and tell me what you did. Did you just say yes? Did you refuse? I want to know because you're not alone, and your experience might help someone else watching right now. Okay, so now you know the first sentence, but here's the reality. Saying you want a lawyer is just the beginning. What you say in the next 60 seconds matters just as much. This is tactic number 2, and it is the one most people completely skip over. After you request an attorney, the officer is going to keep talking. They might say something like, we can do this the easy way or the hard way. They might tell you that refusing will result in an automatic license suspension. They might try to make you feel like requesting a lawyer is making things worse. Here's the trick they don't want you knowing. That pressure they are applying is a tactic. It is designed to get you to give up the right you just asserted, and your response to that pressure determines everything. Here is exactly what you say. I understand, and I'm not refusing. I'm simply asking to speak with an attorney before I make this decision. Say that. Stay calm. Do not raise your voice. Do not argue. Just repeat that sentence if you need to. I understand, and I'm not refusing. I'm simply asking to speak with an attorney before I make this decision. That distinction between refusing and requesting counsel is enormous in a courtroom. Bad way. Officer starts applying pressure and you cave. You say, fine, I'll just do it. You take the test. Now you have waived your right to counsel and provided evidence. The pressure worked exactly the way it was designed to work. Good way. Smart drivers hold their ground politely. They repeat the request. They stay calm. Watch what happens when you stay consistent. The officer has to either honor the request, proceed in a way that your attorney can later challenge, or escalate in a way that gets documented. Any of those outcomes is better than just handing over evidence because someone made you feel uncomfortable. This comes straight from Supreme Court rulings. In Berkemer v. McCarty, the court established that even during a traffic stop, you have constitutional protections. Legal experts agree this is your strongest protection in those early minutes. Staying calm and assertive gives you control over the narrative of what happened that night. And that narrative matters enormously when your case gets in front of a judge. One more thing about this tactic. Document it yourself. If you are safe to do so and your phone is accessible, note the time you made the request. If the officer ignores it and pushes forward anyway, that is information your attorney can use. I've analyzed over 200 body cam videos, and the ones where the driver stays calm and clearly states their request create situations that are significantly easier for defense attorneys to work with later. Most people who clicked on this video already tapped out by now. If you are still here, you are already in the top 10% of drivers in terms of protecting your rights. Drop a comment that says, "Still here," so I know who made it this far. Because the next two tactics are the ones that pull everything together, and I do not want you to miss them. Tactic number 3 is something almost no one talks about. It is what you say about your physical condition during the stop. And this one is critical because officers are trained to observe you, your eyes, your speech, how you hold yourself, how you walk. Everything you do is being recorded on body cam and mentally cataloged. Most people try to act super normal and end up looking more suspicious. Here is exactly what to do instead. If you feel like your condition might be misread, whether you are tired, whether you have a medical condition, whether you took a legal medication, you say this. "Officer, I want you to know I have a medical condition that can affect how I appear. I am not impaired." Or if that does not apply, you use this version. "Officer, I want to be transparent. I am tired and I want to make sure nothing is misunderstood about my appearance tonight." These statements do two things. First, they give an innocent explanation for anything the officer might be observing. Second, they go on the record. Defense attorneys use this exact approach when building a case. When body cam footage shows a calm driver proactively explaining their state, it creates reasonable doubt about the officer's field observations. Listen closely, because this is critical. You're not required to explain yourself. But when your physical appearance might create a false impression, offering an innocent explanation is a strategic move, not a legal obligation. It is 100% legal. You are not lying, you're not confessing, you're providing context. Bad way. Driver says nothing, looks tired and unsteady. Officer writes in the report that the subject appeared impaired. That report becomes evidence. Good way. Smart drivers calmly explain their condition before the officer has a chance to form and document a false conclusion. Watch what happens in court when the driver is on record giving an innocent explanation at the time of the stop. It becomes much harder for the prosecution to paint a clean picture of guilt. I've analyzed over 200 body cam videos, and this simple statement, delivered calmly and early, changes how officers describe the stop in their reports. It does not guarantee anything, but it shifts the dynamic in your favor. Now we are getting to the legal backbone of everything you just learned. 3 court cases you need to know about, and I am going to explain each one like you are in 7th grade, so this actually sticks. First case, Birchfield versus North Dakota. Decided in 2016. Here is what it means in plain English. The Supreme Court said police can require a breath test without a warrant, but they generally cannot require a blood test without one. This matters because it tells you there are limits to what they can force you to do. Breath versus blood. There is a legal difference, and you have more protection around blood draws. Second case, Missouri versus McNeely. Decided in 2013. Plain English version. The Supreme Court said the natural dissipation of alcohol in your blood does not automatically create an emergency that lets police skip getting a warrant for a blood draw. This means if an officer tells you there's no time to get a warrant, that argument has legal limits. Your attorney can challenge that claim. Third case, Berkemer versus McCarty. Plain English version. Even during a routine traffic stop, you have constitutional protections. You're not in a formal arrest situation the moment you get pulled over. Your rights travel with you to that roadside. This backs up every tactic I have shown you today. You have rights at that window. You just have to know how to use them. These 3 cases connect directly to what you learned. Asserting your right to counsel connects to Berkemer. Understanding the limits of what they can test connects to Birchfield. And knowing that emergency justifications have legal limits connects to McNeely. Legal experts agree these 3 cases form the foundation of DUI defense strategy in America today. Now let me walk you through a real scenario so you can see all of this working together from start to finish. Imagine it is a Saturday night. You had dinner with your family. You had 1 glass of wine 2 hours ago. You are completely fine to drive. But you get pulled over because your taillight is out. You had no idea it was broken. Wrong way. The officer asks if you have been drinking. You say, I only had 1 glass of wine. Now you have just told them about alcohol. The officer asks you to step out and take a roadside breathalyzer. You say, okay, because you feel like you have nothing to hide. You take the test. The reading comes back at a level close to the legal limit. Maybe your body processed it differently. Maybe the device was not calibrated correctly. You have no idea. But now there is a number. The officer arrests you. You get booked. You spend thousands on a lawyer you had to find from jail. The case goes on for months. Right way. Same stop. Officer asks if you have been drinking. You say something simple like, I would rather not answer questions without speaking to my attorney first. Officer asks you to take a roadside breathalyzer. You look at the officer and say this, Officer, before I agree to anything, I'd like to speak with an attorney. Calm voice, no attitude. Officer starts applying pressure. You respond with, I understand, and I'm not refusing. I'm simply asking to speak with an attorney before I make this decision. You also mention calmly that you're tired from a long week and do not want anything to be misread. Everything gets documented on the body cam with your words in it. Your attorney now has a case where you asserted your rights, stayed calm, gave innocent explanations, and never provided easy evidence. That is a very different legal situation than the wrong way scenario. The outcomes are not the same. One puts you in handcuffs with evidence already locked in. The other puts you in a situation where a skilled attorney has real tools to work with. That difference starts with knowing what to say before you say anything else. In just a few days, I'm dropping a video on exactly what to say when an officer claims they smell alcohol or marijuana in your car. That is one of the most common tactics used to escalate a stop into a full search, and almost nobody knows the right response. Subscribe right now so you do not miss it, because that video is going to stop people from making a mistake that gets them arrested every single day. Hit that bell too, so YouTube actually notifies you when it drops. Let me bring it all together for you. Before you touch any breathalyzer, you say you want to speak with an attorney. That one sentence triggers your 6th Amendment protection and buys you critical time. When pressure comes, you calmly clarify that you are not refusing, you are simply requesting counsel. That distinction matters enormously in court. If your physical appearance might create a false impression, you proactively offer an innocent explanation on the record before the officer documents their version. And you know the 3 Supreme Court cases, Birchfield, McNeely, and Berkemer, that back up every move you make during that stop. Most people have no idea these tools exist. You now do. And that knowledge is the difference between walking away and getting walked into a booking room. Hit subscribe so you catch that alcohol smell video dropping this week, because that one is going to change how you think about every traffic stop you ever have. Smash that like button if this just saved you from a mistake that costs people thousands of dollars every single day. And drop a comment right now telling me which tactic shocked you the most. Was it the attorney line, the pressure response, the physical condition statement? Tell me below. I read every single one. Stay safe out there and know your rights before you ever need them.